Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Before we get started, I just want to make sure everybody can hear me.
The conference is now in conversation mode. Message, press star. To send this message now, press pound or hang up.
Not sure what happened there. Can you guys hear me okay? Hello? Can you hear me okay?
To replay your message,
Yes.
press 1.
We can hear
To
you.
delete and re-record your message, press 3.
I don't know
For
what's...
delivery options, press 4.
I have
To
no
send a
idea.
fax, press 6. To cancel this message, press star.
All
To
right.
send this message now, press pound or hang up.
No idea where that is coming from. Oh well.
Yes, we can hear you. We can hear you.
As long as you can hear me, I'm good. Okay, let's get started.
Your message has been sent. Thank you for... The conference is now in presentation mode.
Yeah, we have some weird stuff going on. I think there's an IP conflict in one of our machines, and that's causing a lot of issues. So, okay, good afternoon, everyone. Welcome. Today is January 20th, 2022, and this is our two-weekly community conference call where we answer the questions that have been posted to the best of our ability, and whatever remains, if time remains, we take new questions. Okay, so let's do some of the questions that I have marked as frequently asked questions first. Puneet Mehta has a relatively unique situation where a postdoctoral holder, his wife, after doing a PhD in clinical psychology in 2016, she had to take a gap for due to marriage, kid, and brain hemorrhage. Oh, now she's well again. Can she apply for EB1B? So the question really boils down to one issue, which is an EB1B application possible if you have a gap in your employment? Okay, I am not quite clear about the answer off the top of my head. If it were an EB1A, I would have said it's a problem because EB1A says you must have sustained national or international acclaim. Now, does sustain allow for a gap? I think so. Even in sustained, we had a green card we did for a successful EB1A for a journalist. She was quite well accomplished, of course, one of the top people in the country in India. And then she took a few years break where she was writing her blog, which was quite popular. But one of the issues raised by the government was the interruption and how it was sustained. And we took the argument that the word sustained doesn't mean sustained all the way through. It can have interruptions as long as looking over a long period of horizon, you can see that the person had sustained national acclaim. Now for EB1B, I don't believe that is necessary. I don't remember off the top of my head, but even if there was a gap or there is a gap, I think you could still make a case. Personally, in the first place, I don't think EB1B requires a sustained period of recognition. And two, even if it did, I think it can be overcome. There are several things that support that argument. If you have a follow-up question on that, press *5. So the answer is yes, potentially possible. *5 if you have a follow-up question on this. Okay, let's go on to the next frequently asked question. This is very common. Date of birth and name corrections in birth certificate. So his wife's birth certificate has mistakes, errors in names, and also the date of birth is wrong, 3 months behind. We recently had a very weird case where somebody retained us to file some paperwork for them, and we took the case, and then during a conversation I noticed that the date of birth was deliberately inserted incorrectly by the family. Okay, how in India many times they will give the wrong date of birth just so that you don't have to waste a school year. So in such a case, to continue with the lie, in my opinion, would be fraud. So I told them, I said I would not be able to take this case further because this is a deliberate lie and we should just explain the situation truthfully to the government, to the US government. And they, of course, didn't want to do that, and they found a lawyer who was willing to overlook this issue, and that's entirely up to different people. But if you took my advice, I would state whenever you have a date of birth issue, this one is an easy one because it's a 3-month discrepancy. Sometimes people have misstated or misrepresented their date of birth by 1 year simply because of the school year issue. And again, that's not your fault, that's your family's fault, and you should not be held responsible for it. How do you deal with these birth certificate issues? One is the date that I just talked to you about. It's better to come clean, tell the government what actually happened, start correcting the records, going back as far as you need to. You need to sanitize your records, okay? How about the names? Now, for example, my name Rajiv. It can be spelled R-A-J-I-V, R-A-J-E-E-V, R-A-J-I-V-E, R-A-J-E-E-V-E. There's so many ways to spell this because the spellings are phonetic. We spell as it sounds because Hindi doesn't have a directly corresponding script to English. So therefore, all names are semantic. If the difference is just a semantic difference, just the spelling difference, I wouldn't worry about it too much. Okay. Now, if the spelling error, if it's more than a spelling error, or it's not a semantic mistake, not a phonetic, not semantic, phonetic mistake, then I think you would need affidavits, further clarifications. And sometimes I have even asked clients to go far back and even ask the courts in India to correct the names if the government won't. So hopefully it doesn't come to that. Most of these cases are pretty easy to deal with. We explain the situation and we show the government that we are in the process of correcting our records, and that usually works out. Consulates, birth certificates, etc. are not really very useful in my opinion, and I haven't wasted time with those. What I do is I usually correct the situation, have the client start correcting it, provide evidence to the government that we are correcting it, provide affidavits, and usually that has worked out for us. *5. If you have a follow-up question, press *5. If you have a follow-up question, press *5. Okay. Let's go on to the next frequently asked question. Oh my God, this is another one. I deal with it at least once a day. COVID-19 delays in tourist visa extensions for B2 holding parent and applying for their green card. So there are two separate issues. One issue deals with filing extensions when parents are visiting. Now, the United States government has made a lot of errors, legal errors, in this area of the law. There is a section of the law called 222G as in girl. Immigration and Nationality Act 222G says this: if somebody overstays their I-94, their period of admission legally allowed, they will have to go get a new visa stamp because their visa is considered to be automatically cancelled. However, there are two exceptions to this rule. One exception is, let's say I was admitted till January 1st. I left the United States before my extension request expired. I asked from January to June. Okay, so I came in prior June. I was here for 5 months. Then I applied for an extension. I applied for the extension within the time of my stay while I was still legal. And a couple of months after applying, I left. Now what has happened here, I left during the requested period of stay. My visa should not be considered to be cancelled. That is the rule. And this rule is actually available in the government's own standard operating procedures. However, they violate these rules. We are just getting hired to fight one of these cases. I think it's a nonsense approach the government is taking. When an individual leaves while the application is still pending and within the time requested in the extension application, they are still considered to be outside the 222G. The second exception to 222G is if your request is granted. So let's say in June, I was admitted till January, I asked till June next, and the request was granted. I'm no longer subject to 222G. That should be quite obvious because a legal request was legally granted. Okay. Now this is one set of problems. The second set of problems, I'm not going to repeat again, applying for a green card. We have this in our frequently asked questions. Please review our frequently asked questions. This issue of applying for a green card while parents are visiting has been extensively dealt with several times. So I'm not going to repeat it. Okay. So the answer to your question is, can you apply for their extension? You should. You have to, because you don't want them to get out of status. You can apply for a third extension. Will it cause any issues in the future travel? Yes. The government is going to claim that they have to get a new visa stamp. And usually that should not be a problem. These are unique circumstances. So, of course, and if you apply for and get a green card, all that is moot anyway. Okay. So can filing a third extension create a bigger issue than filing a second extension? I don't think so. I think they are all a part of the same problem. One is the COVID problem, and the second is government misapplying the laws. I wouldn't worry about it. At this point, applying for a green card is definitely a viable option. And once the green card is applied for, all these issues go away. There is no problem. Because remember, immediate relative of a U.S. citizen, such as parent of a U.S. citizen, spouse, child, they are considered to be eligible to receive their green cards even if they have lived in the United States illegally for 20 years. So therefore, this is not an issue. But make sure they don't travel until they get their green card. Star 5, if you have a follow-up question on this. Star 5. Okay, I have a question from area code 925. 925, where are you calling from?
Rajiv, I'm calling from Texas. So you just answered my question.
Yes, sir.
But as a follow-up, I wanted to ask if I file for the third extension, and because the other two extensions are still pending in pending status, and suppose she flies back somewhere like a month or two from now, once the COVID cases get lesser, and then I withdraw the application once she flies back. Is that okay? Or
No, don't withdraw the application. No, don't withdraw the application. Inform the government that you want extension only till the date she left.
Oh, okay.
Got it?
Okay.
What else? Yeah, see,
okay. Thank you.
We don't think about these things, but with practice and with time, you kind of start looking at these patterns and start thinking of these solutions. So that's the best solution in my mind.
Sure.
Okay. Good luck.
Yeah, and we have a valid reason for the third extension.
Yeah.
She was like,
I saw that.
Yeah.
Yeah, I saw her situation. So good luck with that.
Yeah.
Okay. All right. Bye-bye.
Thank you, Rajiv.
You're welcome.
Bye.
Bye-bye. Area code 860. Where are you calling from?
Hello, Rajiv ji. My name is Anshna. I'm calling from Miami, Florida.
Yes, ma'am.
Good afternoon.
Good afternoon.
So I had a follow-up question on the guidance that you just provided. Thank you for that. My question is, once we get a green card for a parent, what rules apply to maintain it? In the sense, right now, because of the extension,
all right.
it's still in the processing.
This is a long discussion. I'm actually writing a comment on this. It should be coming up in the next couple of weeks. If you can wait that long, I'm writing a comment on maintaining your green card, the facts and the fantasy people have about it. I have it in my radar. It's one of my things to do. I should be putting it up in my Economic Times authors page. So once it comes up in Economic Times, I'll publish it. The bottom line is your permanent home should be in the United States. You can go abroad for a few months, less than 6 hopefully, and come back, but your permanent home should be here. That's the bottom line, but I'll expand on this when I write. Okay?
Perfect. Thank you very much.
You're welcome. Good luck. Okay, let's go back to, do we have any other frequently asked questions? We do not. Okay, let's go back to our regular questions. And this is where we begin. Okay, this is a question about L2 dependent spouse and their employment authorization. I think that the litigation was largely useless. At least for H4 people, it didn't do much. And for L2 people, it merely reiterated something which was already clear in the law, but it did help more than it helped H4 people. So from what I remember, I haven't read this for a while, from what I remember, the government said in the settlement for L2 people, first of all, within 120 days of the settlement, we are going to change the way we issue I-94s. The I-94 for L2 will now contain a statement that you can work with this, and that makes it very easy to fill out Form I-9. But as far as the extensions are concerned, and this is what I remember off the top of my head, it's really not very helpful. The settlement says you can, if you have filed for an extension of an EAD in a timely manner, you can continue working for up to 180 days or time remaining on your I-94, whichever is lesser. So yours is expiring in June. And if you file, you can continue working till June because that's when your I-94 expires. But you don't get time beyond that. That's what I remember off the top of my head. You can have your lawyers look at these rules, but the rules have not really helped much, or the settlement hasn't helped much. Even when it goes for extension, as far as I know, you cannot continue working because your EAD card would have expired in March, and you can only work till the time remaining on your I-94, which is June, and you don't have any more time than that. That's the way I remember it. Okay, so to summarize the answer, you should be able to work till June and no more, no matter what, under the circumstances you have described, from what I remember. *5, if you have a follow-up question on this, press *5. Okay, let's go on. Oh, here's another question from area code 720. 720, where are you calling from?
Hi, Rajiv. I'm calling from Colorado.
Yes, ma'am.
And this was my question. So, in case I leave the country and come back and my I-94 is renewed and my visa also renews on time, then can I work on the same EAD card for 3 more months?
No. Then the situation will change. First of all, remember, your husband must get his L1 approval before you can go get L1 visa stamp and come back, right? So when you come back, I think 120 days would have passed from the date of the settlement. So they should give you an I-94 that is itself an employment authorization.
Okay.
So therefore, yes, traveling out should help, not for the reason you think. It will help because the I-94 would have changed.
Okay, so there will be a statement in I-94?
Yeah, there should be something. Yeah, that should say that you're authorized to, I don't know exactly what form it will take, but it should say that you're authorized to work incident to status. All right.
Okay, because I recently came, I visited India for to meet my family, and I came back on December 3rd or 4th. But in this I-94, they have not added anything.
Yeah, I'm not sure when was the settlement. I think it's less than 120 days. It's not been 120 days yet. Okay.
Okay.
Good luck.
Got it.
All right.
Yeah. Okay.
All right. Bye-bye.
Yeah, thank you so much.
You're welcome.
Thanks.
Okay, so the next question. Okay, so this is a problem where somebody, Ankit was in the United States. They didn't pay him for 3 months. Then they finally found him a project. And when he went back for visa, the employer realized, oh, the consulate is asking too many questions. They withdrew it. Now, question, am I considered out of status because of the past payroll? You were out of status, yes, but it's not your fault. Will I face any issues with H1b stamping or POE with the new POE? I don't know what POE means. POE usually means port of entry. And the answer is, this is what you should do. You should file a complaint with the, what is it called? Department of Labor's, it's just Wage and Hour Division. Yeah. File a complaint with the Wage and Hour Division. Your employer should be paying you that 90 days salary. The reason is not just because you want the money. It's because you want to make it clear on the record that it's not a conspiracy. You did not conspire with the employer. You wanted to get paid. You were ready to work. But if they don't give you work, what are you supposed to do? I think with that, your situation becomes quite clear. While you may be subjected to some administrative review 221G type thing, but it's not going to be fatal to your application. So you should be okay, in my opinion. *5, if you have a follow-up question. *5. So if you actually just Google complaint, Wage and Hour Division, they have a form, WH something. You file it. After that, you are done. You don't have to do anything more. They'll take care of it. They probably will get you the 3-month salary as well. Area code 813, Florida. Florida, go ahead, please.
Hi, Rajiv. This is Ankit. It was my question. So the question that I had is like, as per your suggestion, so it's of 2015. So do you think if I raise a
they're not gonna
against my employer,
they're not gonna do anything. When they only do it for 2 years, but you can go ahead and file it and keep a copy of it, because at least you would have done your best.
okay, so I can at least show it during stamping.
Yeah, just keep a screenshot or a copy of your filing. And if there is a problem, you can say, I filed a complaint, but I found out about having to file a complaint much later than I should have. I would have filed it earlier. But as soon as I found out that I should file a complaint, I did.
Okay, so that might save me by getting the
I think so. I think so. I think it shows that you did not have any complicity in this scheme that the employer had. They should have paid you for those 3 months. Okay.
Yeah, but because I came and I didn't have project, so that's all.
Yeah, but that's not your problem. That's their problem. So they should have paid you.
Right.
So in any case, that's what I think you should do. All right. Good luck. Okay, let's go on to the next question. Maintaining H1b status. This is from Shilpa. Maintaining H1b status while waiting for green card. Spouse is primary. So I've got my green card EAD, good for 2 years. He is the primary. Now I want to use EAD. Can I get an H1b again? Oh, absolutely. You can get an H1b again. Okay. So you have a valid I-140, which was approved. And if ever you wanted to go back on H1, you could. You'll just have to step outside the United States and come back. There's no issue. Even 10 years down the line, as far as I know, you should be able to convert back to H1B if you wanted to. So going on to EAD is not an issue for you. *5, if you have a follow-up question on this, *5. Okay. Let's go on to the next question. So this has too many issues. You should just talk with your own lawyers and set up a consultation. I'll try to cover as many things as I can, but this is too much. You're asking for a lot of, it needs about 15 minutes discussion, and I don't have that time. So let's do the best we can. I mentioned that I-140 has been approved, for 485 is pending for 6 months. You can be unemployed until receiving the RFE. So you have 6 questions. I'll do the best I can. Could the unemployment reason be due to expired visa? You don't need a reason. Should the job offer in response to RFP be in the same field? Yes. Actually, if you are porting your green card, which is called AC-21 portability, you have to get a same or similar job. But if you are just porting your priority date, it can be any job. If the green card gets denied, would this be considered overstaying the visa? No. When you have a 485 pending, you are not overstaying your visa and you are not banned from entering the US. Can I apply for TN again? TN requires non-immigrant intent. So if there is a past green card application from you, your TN can be denied on that basis. But H1b cannot, L1 cannot. Does expired TN visa called CG denial? You mean green card denial? I don't know what that question means. So if you have a really quick follow-up question, I can answer it, but don't ask me any more detailed questions. *5 if you have a follow-up question. So yeah, bottom line is you don't need a reason to be unemployed, and the field should be the same or similar if you're using AC-21 portability. And this is not overstaying your visa. Okay. Next question. Extended absence from US while maintaining permanent residence status. I am going to write a comment on this, like I said, and I'll publish it. I will put it on the social media, on our Instagram, LinkedIn, Facebook, Twitter, all these accounts, or Google. You came back within 365 days. See, the bottom line, again, getting into all these details, the bottom line is very simple. You must establish your permanent home and keep it established in the United States. When you have extended absences, they can ask for an explanation, and if the explanation is not satisfactory, they could take away the green card, or at least put you up before an immigration judge and an immigration court. Is there any precaution I should take when out of the US? Well, you need to, this is a very difficult question to answer. Look at our frequently asked questions. This is a long discussion. Look at re-entry permit, which is Form I-131, and also look at Form N-470. You're not eligible for that right now, but you should know about it anyway. N as in Nancy 470 and Form I-131 re-entry permit. Understand what they mean. But really the only way to protect your green card is to live in the United States. *5 if you have a quick follow-up question. *5. H1b cap exempt rules. Question number, there is a follow-up question. Guys, be a little quicker, okay? Area code 203, that sounds like Connecticut, right?
Yes, Rajiv, sir.
Okay,
so
sir.
I have a quick question.
Mm-hmm.
So if I stay outside of US, within that limit of 6 months, like if I'm out for 4 months, that should be okay, right? That time period, 4 months.
As long as your permanent home is in the United States. Okay. It shouldn't be that you are living in your home country and visiting USA. You should be living here. Okay.
Okay.
Good.
I have a permanent, apartment house.
Yeah, that doesn't mean anything. That doesn't mean anything. Wait for my comment to come out. I will publish it, like I said, in the Economic Times. You can take a look at that article. That should be pretty much self-explanatory. Bottom line is very simple. When I ask somebody, where do you live? They don't get into all these details. I have my apartment in California, but I have a single family home in Colorado. Bottom line, do you actually live in the US or not? One particular indication of that is you have a job in US. Okay, or you have your business in US. So, good luck. All right, next question. H1b visa cap exempt rules. I-140 filed by company approved. Company A has been approved. Priority date is not yet current. You move to company B. My H1B was extended based upon the approved I-140. You moved out of the United States with 2 years remaining on the H1B. Is it possible to get cap exempt H1B? Absolutely. The answer is yes. Company C, yes. Star 5, if you have a follow-up question on this. Star 5. Okay, yeah, you're still cap exempt, even with company C. F1 visa 90-day rule and the adjustment of status. An F1 visa holder married to a US citizen, could there be an issue because of the 90-day rule? First of all, as far as I know, the government has scratched the 90-day rule, but the basic principle remains the same. You should not lie about your intentions when you enter the United States. Okay, so I am not sure. Are you on the call? Press star 5 if you're here. I have a quick question for you. Press star 5 if you're here. Star 5 on your phone. Okay, so the most important thing is that you must have entered the United States as a genuine student, attended classes. And if you were doing all that, the fact that you got married to a US citizen should not have a bearing on anything. Okay? Next question. Pravina says, will minor children with both parents as green card holders allowed to enter US after 1 year? So, okay, so I have written a comment on this. Please go to Google Economic Times Rajiv S. Khanna. That's my name. Go ahead and Google that. And when you come to that, there is a complete comment by me which explains what the current policy of the government is. And I'll briefly tell you this, that what they are saying is if your green card has not expired, even if you are out for more than 1 year, will let you come into the United States, and the judgment will be made at the airport whether it's your fault or somebody else's. So read up on that, and if you still have a follow-up question, go ahead and come back to us. Star 5 if you have a follow-up question. Yeah, I would like them to be brought back into the United States. That's the way I would do it, but you can take a look at that article, that comment. Next question. Change of employer after I-140 approval. This is question number 13. Change of employer after I-140 approval and renewing H1b indefinitely. Currently on the 6th year of my H1b, same employer for the last 6 years. I-140 was approved more than 4 years ago, or about 4 years ago. Priority date of 2018. Can I switch my employer now even though my initial H1b period is ending? And the answer is yes. You can use that I-140 for extension of the H1b beyond 6 years with any employer. Am I eligible to keep getting H1b extensions even if I'm not with the employer who filed the I-140? Yes. Will I retain my priority date? Yes. Star 5 if you have a follow-up question on this. Star 5. Okay. Can I renew my driver's license while I-485 is pending? This is a question of state law. All 50 states have slightly different rules. So you're going to have to check with the local Department of Motor Vehicles and see what their local rule is. All right. If I renew based on AB60, which is a driving license for undocumented, why should you do that? You are a documented individual. Why should you file it as an AB60, whatever that is? Will it have an impact on your 485? I don't think so, but you should do things meticulously correctly. So in my view, it should not be done like that. Could it affect the green card process? I wouldn't want to find out. I would rather do things legally and completely truthfully. Star 5 if you have a follow-up question. I'm pretty sure almost all states have some provision for AOS people when your 485 is pending. Okay. Next question number 15 is change of status from H4 to F1. I'm a dentist. I came on F1. Then after 1 semester, I got married to an H1b holder, went to H4, dropped from my MPH program, dental school, got admission. I will start in July. I want to transfer my H4 to my to F1, H4 will expire in August 2022. You can apply for change of status within the United States, sir. Is there any risk? Yeah, there's always a risk, because remember, F1 can be denied if you have an immigrant intent, so you then have to get an H4 and come back. And I don't think you need to file an extension if you file for an F1 within time. Those rules have changed. Can I file two applications together? You can, but there is a problem. So let's say you got your F1 approval and then your H4 approval comes. You will be back on H4, not on F1. So whichever gets approved the last, they call it the last action rule. It's a dumb rule, but it's something the government has held for a while. So if I were you, I would just file the F1. But that's my take on this. *5 if you have a follow-up question. *5. Okay. Number 16. Oh, there's a follow-up question. Area code 216. 216, where are you calling from?
I'm from Cleveland, Ohio.
All right, G. Cleveland, Ohio. What is your question?
Yeah, my question is like, if I file my F1 extension and after like 2 years they give me a rejection, then I have to leave country, because at that time I don't have any,
no big deal. So what?
status.
Just go get H4 visa stamp and come back. No problem.
But what about like if my school is still on?
You go get H4 visa stamp
I
and
have
go
to
back
go
to
in-
school. You can go to school on H4. You're allowed.
No, but at that time, like if they reject my F1, then I don't have any status.
I just told you, you will have to leave USA, get an H4 visa stamp and come back.
Okay, yeah.
Okay.
Thanks.
Good luck. Let's see. Area code 925. Where are you calling from? Area code 925.
I'm calling from California.
Yes, California. Go ahead. How can I help you?
Yeah, so just a follow-up question was that whenever you're applying for like a F1, like from H4 to F1 or whatever delays, if it is from their side, if you have applied in time and that document doesn't come, then the responsibility is not yours. You can continue, is it? Is
Yeah,
that what you
the
mean
law
by
says,
file it in time?
the law says, if you
Yeah.
file a good faith timely extension application or change of status application, as long as that is pending, you are not in illegal status. You are considered to be maintaining what is called authorized period of stay. You can stay in the United States.
Okay.
All right.
Okay.
Good luck.
Okay, thank you.
You're welcome. Okay. Can I apply for H1b? Number 16. Apply for H1b while 485 is pending? Can I apply for H1b while TN expired 485 is pending? Yes, you can. Can I use attorney different from the one who filed 485? Sure, that's your employer's call. H1b is the employer's application. If they let you hire anybody you want and they pay for it, they have to, you can use any attorneys. What documents my company needs to provide for H1b visa? That's a question beyond the scope of this discussion. So if the company has done H1Bs before, discuss it with them. They probably have lawyers. If they don't want, if you have problem with their lawyers, you can ask them if they will let you have outside counsel. But certainly you can do that. One problem though, you are a Canadian citizen. So if you get an H1B, you'll have to go to the border and come back in again. Okay, because you are on 485. To convert to H1B would require step outside and come back in. *5. This is not the same for other people, guys. Only for Canadian citizens. Other people need to go get a visa stamp. Canadians do not. *5 if you have a follow-up question on this. Okay. Let's see. Where is this from? Area code 281. 281, where are you calling from?
This is from Texas.
Yes.
Hi, Rajiv ji.
Hello, sir.
And this is not, I didn't pose the question. I have a question on the same lines. Would that be fine? Can I go ahead?
Yeah, if it is a follow-up on this question, I can answer it. But if it is a new question, you'll have to wait.
Yeah, so, okay, so this is from H4, and this is for my wife, and
no,
GCEAD
you have to wait. Sorry.
Okay.
Okay, only follow-up questions. I don't want to take new questions till the end if we have time remaining. That's why we encourage you to post your questions. We'll have about, I think, 15 minutes. In that, I can do a lot if you keep your questions brief and to the point. L1b change of status. This is, I think, the last question today. L1b change of status to approved H1b with consular processing. Okay. Happy New Year to you too, Kumarji. One of my friends is working on L1b for company X. He's got an H1b approved through consular processing with company Y. Can company X initiate new H1b petition without going for lottery? And the answer is, in my opinion, yes. Sometimes, actually not sometimes, government takes the position that you are not outside the lottery queue until you get change of status or a visa stamp. But I have done cases of H1b transfer of people who never got a visa stamp. So it's worth a try. Can company X transfer H1b with just a receipt notice? No paychecks from company Y? Yes, they can. Is there any risk involved, current L1? No, there should be no risk to the current L1. I don't see any problem. Can company Y revoke the approved H1b? Of course. If yes, how can company X pull the details? They cannot. This is not something you can just find on public records. Okay. *5 if you have a follow-up question. *5. All right. Anybody has any question, press *5 on your phone. I'll do my best. We have about 18 minutes. Area code 813. 813, where are you calling from?
Hi, I'm calling from Florida.
Go ahead.
Yeah, so I had already posted the question like the name Shilpakar above.
Okay, so if you have posted,
regarding my green card.
Yeah, if you have posted, I have answered. Then wait for the recording. Okay.
No, I just have a follow-up question on that.
Okay.
Yeah. So what I'm asking is like, so because I have the green card, so as soon as the green card becomes invalid, so will I have to travel back immediately, or is there a specific time period in which I have to file the H1b process?
Are you talking about if you have an employment authorization through your husband and the case falls? And the answer is yes, you should travel actually right away. But you could take a couple of weeks to get out. But after 180 days, you will become subject to 3-year bar. So leave as early as you can. Okay?
So, okay, I have to leave early, but since if I'm working for the green card EAD is with the same employer who has my H1B as well. So will that be any advantage? Because
no advantage.
I have the H1B.
Ma'am, no advantage. No advantage. No advantage. All right?
Oh, okay.
Good luck. Keep up, guys. I'm very quick in answering. Listen carefully. Keep up. Area code 408. I want to cover everybody's questions. Area code 408, California. Go ahead.
Hello.
Yep. Hello.
Can you hear me?
I can hear you just fine.
Yeah. Sorry. So my question is like, so if the employer is not supporting, can I still on the downgrader and waiting
okay,
for update after my biometric?
Stop. No, you cannot. Next question.
So why?
Because it is the employer's application. You can't drive your boss's car just because you want to. It is your boss's car. They can let you drive it. So the bottom line is I-140 is your employer's application. You are nobody in that application.
Okay, so we cannot file even from outside.
That's why I said no. Any other question?
No, thank you.
Good luck. Area code 571. I think that's Pennsylvania or Virginia. 571, where are you calling from?
Hi, this is Hema. I'm calling from Northern Virginia.
Okay.
Good afternoon, sir.
Good afternoon, ma'am.
So, I have a question related to my sister. Basically, we are 4 brothers sisters. 3 are U.S. citizens, and we all are here except one sister who is in India. Right now, she's visiting here on visitor's visa. She has some health issues, mental health issues. Our parents are deceased. She's married but abandoned by her husband. So now she's totally dependent on us. We never filed a green card for her.
Okay, stop. Stop. There's nothing you can do for her. Okay, because if you apply for her green card, that will take about 15 years to come, and she cannot stay here 15 years. She has to leave. Okay, now unless you have an investment and she can manage the investment, or at least actively participate in it, and you can afford to spend $500,000 to $1 million in getting her settled, or she's a professional and she has an H1 type option available, you can do nothing for her as just a sibling to sibling. Unfortunately, that's the rule in this country. Okay?
Okay, thank you.
Good luck. Area code 516, where are you calling from? Area code 516.
Hi, good afternoon. This is Kevin from New York.
Yes, sir.
Hi, my question, it's more like a general question, but still related to my personal situation. My question is regarding H1b. So my current employee, they're filing H1b for me, and I do have 2 other potential companies who offered me a job, and they're also ready to file H1b for me this year in the lottery. So my question is, if multiple companies are putting their lottery applications for me, will I have to let my current company know that I'm having other applications as well from different companies?
As far as I know, you do not. You do not have to let employers know. But keep this in mind, all 3 employers must be completely unrelated. They should have no common directors, officers, nothing common, no common projects. If that is true, it is legal for you to file multiple applications. And as far as I know, it does not need to be revealed, but you can double check that. You can look at the registration forms, etc. I don't think you need to reveal it. Okay?
Okay. Yeah, that was my question. And all 3 companies are completely unrelated.
Yeah, then it's legal to do that. Good luck.
All right. Thank you so much.
You're welcome.
Thank you so much.
You're welcome. Area code 747, California. Go ahead, please. 747, California. Area code 747. Okay, I'll pass you. Area code 210. I don't know where you're calling from. 210, where are you calling from?
Hi, Rajiv. Thanks for taking my question. I'm calling from Canada.
Okay.
I'm living across the border of Detroit.
All right.
I'm having H1b. I had a previous employer, 140, filed back in, approved in 2014. And it was revoked in 2018.
Oh, good.
By the same employer.
Oh, good, because that preserves all your rights. So 2018 is good. Keep going.
Sorry, sir.
I said 2018 is good.
Yeah, it was revoked in 20.
Yeah. Okay.
Yes, sir. Yeah. 2018 June, July timeframe they revoked. But I moved to a different employer.
Okay.
After that, and they filed the perm recently. But my priority date is gonna be current in February. Like in final action table. So I'm a little bit worried because it's my permit is still processing, and it might take a year or less than a year. How that will be.
Well,
I heard, like,
hey, look, there's not
so.
much you can do about it. It's gonna take whatever time it takes. But the good news is, if you are that far advanced in your priority date, chances are it's going to be fine, because remember, if the priority date comes and you haven't filed, you can still file whenever the priority date is current again. It probably will stay current for you because yours must be an old case. So it's not something to worry about as far as I can see.
I don't have to. There is nothing like a time limit. I have
No,
to
not at all. Not at all.
PD becomes current.
Not at all.
Okay.
I'll give you an example. This is important because a lot of people might have this question. So let's say my priority date is 2012. It became current in 2022 January. I did not file. I'm ready to file, let's say, in December of 2022, and the priority date is still current. It is now, of course, it's been current for many years and many months. In between, it slid back again, but it's current again. Whenever it becomes current or stays current, you can file again. There is no deadline.
Okay. At the time I was in India, so there is like a constant processing to NVC. So do I have to inform them of,
No.
Hey, I'm not in a situation to file now or something?
I don't know exactly. That's something you have to talk to your lawyer about. But I can tell you generically, you have no issue. All right?
Okay.
Good luck.
Thank you, Rajiv.
You're welcome. Area code 925. Where are you calling from? 925.
Yeah. I'm calling from California. I had a question about timing again. That suppose my daughter has got a job and she could apply for OPT. And would you know, like, if these documents also take time, the OPT doesn't come in time, is there anything to expedite? Or
Yes.
Then do you just postpone the job date?
Yes. They actually have an expedite procedure that you can do online. So if you have a reason to expedite, you can certainly ask for it. Okay?
Okay.
Good luck.
Okay, that's good to know.
Yeah,
Thank you.
she can do it through her own account, in my USCIS account, whatever that is. So they have a way of doing it through there. I don't remember the details. All right?
Okay.
Good luck, ma'am.
Thank you so much.
Good luck. Area code 281. Where are you calling from? 281.
Hi, Rajiv. This is from Texas.
Yes, sir.
I had the question before.
Okay.
So the H4 stamped with validity for about 3 years, GCE applied, and biometric pending. Now she has got someone to file her H1. The H1b is filed in premium processing. So the worry is the premium process, definitely H1 will come before EAD. So when she gets on H1, she gets her H1. Can she start working immediately, or there is something additional that needs to be?
No. Hang on. I have a question for you. Is she currently maintaining H4 status?
Yes, she is. Yes.
Okay, then there is no problem. When they file the H1, they will ask for a change of status. The moment the case is approved, she can start working. Okay.
Okay, and the next question is the EAD part, which means if the EAD AP comes, the card comes, can she again switch to GCEAD?
Yes, she can.
Automatically, or additional step required?
Automatically, I don't know what automatically means. Yes, she can switch to it anytime. All she has to do is present it to the employer and they'll change her I-9. It's a 2-second procedure, 10 seconds at the best. Okay?
Okay, so automatically does she need to go out of the country and
it is not automatic. You have to do it, but you don't need to leave the country. It's not a problem. All right?
Makes.
Good luck.
Thank you. Thanks. Right.
You're welcome. You're welcome. Last question is from area code 408, California. Go ahead, please.
Yeah. Hello, Rajiv. Thanks for taking the call.
My pleasure.
So I have a follow-up question. I was talking to you earlier. also about the employer not supporting the EB2 refile.
Right.
What if I get the 485J from the employer? Is it okay?
Okay. You don't currently have a 485 pending, do you?
I have 485 pending with EB3.
With EB3.
And I'm in the process. I wanted to EB3.
Okay.
EB3 2011.
Okay. So you have a 485 pending already, do you?
Yes, I have pending at Nebraska, and it is taking a lot of time. Right, it's 15 months.
Okay.
So I'm thinking of refiling another application.
Okay, I'm asking you this question one more time, sir. I'm not sure you're focusing on my question. Listen to me very carefully because it's your life. Do you have a 485 currently pending?
Yes, it is pending.
Not I-140, 485.
Yes, sir. EB3 downgrade application is pending at Nebraska.
EB3 downgrade is pending. Is the I-140 approved?
Yes, it is.
EB3 I-140 is approved?
Yes, it is approved in the premium process.
Okay. So this is the situation. Your EB3 I-140 is approved. Your 485 has been pending for more than 180 days?
About 15 months now.
Okay.
October
yes,
2025.
you can move over to any employer with the same or similar job and present supplement J. Yes, sir. Okay.
Oh, no. My question is different, actually. I understand about the AC21.
Yeah.
But my question is, if I want to file another application in EB2, it's called refile, right?
Yeah. You have to...
And the employer is not supporting.
Yeah, you have to start a completely new green card with another employer if this employer doesn't want to do it.
But if I want to do with the same employer, I don't have an option with any other employer.
If you want to do it,
the same employer is not ready to file.
Then you can't do anything about it. Then you can't do anything about it.
Yeah, I understand. You gave me an answer earlier, but my follow-up question is, if I'm ready to get 485J from the current employer.
Sir, I'm going to answer this once and then we are done. 485J cannot change your category. It can change your employer or your job. It cannot change your category. Okay?
Okay, thank you.
You're welcome. All right, folks. Listen, I'll see you again in 2 weeks. Stay well, stay safe. I hope everybody is doing okay. Just remember, keep your questions short, to the point, and be on the ball. Bye-bye.